As you're aware, we got your phone, we did a download of it. There is an abundance of evidence that shows you did this. So it's not a matter of if you did it, I just want to know why.
I told her do not make the post. Do not make the post at all. I was scared to tell y'all, like, I'm not no snitch.
You're just as complicit when you allow it to happen. You're right there and watch that.
And then continue to lie about it when you're confronted. That just digs your hole even deeper.
On September 16, 2024, an anonymous Facebook account posted a bomb threat targeting North Ridge Elementary School in Montgomery County, Alabama. Investigators traced the threat to 23-year-old Rayona Hunt within 3 days. On September 19th, Hunt was brought in for questioning. What followed raises several significant constitutional issues.
As you're aware, we got your phone, we did a download of it. There is an abundance of evidence that shows you did this. So it's not a matter of if you did it, I just want to know why. I want to give you the opportunity to explain why. Get out in front of it right now before we go anywhere.
I just told you I didn't do it.
That's not the question.
Hello.
Okay, thank you.
Detective Dalton.
That was my lawyer. I'm Rayona's mom. Now, what's going on? Why was y'all...
Under arrest.
I'm frustrated. Let me calm down, because y'all really got me irritated right now.
Okay.
I done had to come all the way from Springfield.
You didn't have to.
Yeah, I did.
No, you came here on your own.
I came because that's my baby, and then I got to get her daughter.
Okay.
That y'all let just... I mean, but anyway, what is going on?
She was left with her.
Okay, I don't stay here. But she don't stay. This is my other daughter.
Okay. She was left here with her. She came here with her, right? You brought her down here?
Yeah, with my sister.
And your sister said that she could stay with you, and you agreed to keep her.
And I stay right here waiting for
Okay, I don't even want to hear. I can really don't care about that. I'm trying to figure out what is going on. What are y'all trying to pin on her?
We're not trying to pin anything on her.
Okay, she's 23. What makes y'all think that she can send a bomb threat to a school that her daughter and our cousin go to?
The evidence that we have.
But people go on her phone all the time. She let people use her phone. She gave y'all. She was cooperative. She gave y'all both of her Gmail and her iCloud. So now then you set my daughter up because you called me. Be quiet.
Shit.
Because you called me and told me how my daughter come and pick up her phone, but all along you knew you was taking her to jail. When you could have just said that. We done found something in her phone. Can you please have her come in and talk to us? But you set my daughter up. Okay, so where is she at right now?
Montgomery County Jail.
Okay, and what y'all gonna do? Do she got a bond?
No.
Okay, so what are y'all charging her with?
Making terroristic threats.
Making what?
Making terroristic threats.
So y'all gonna have to prove that, though. Y'all just got a phone that's saying that. Anybody can use her phone.
I have her evidence. I have her phone right here.
So you got the iPhone.
So why didn't y'all take it downtown if it was the evidence?
So y'all got the iPhone?
Yes, I do.
Okay, so she's downtown. So how long y'all gonna keep her jail? Because my lawyer about to meet me down
Because my
here.
cousin does shit like that.
That's up to
So
Peaches does shit like that.
So Peaches is gun in her phone?
Right, they always around each other. Yes, you know she's known of that shit.
No, I'm asking you, have Peaches ever had her phone?
Yes, she does.
Okay, so what did Rayona say when you was telling her about the bomb?
Saying it was Paige. Right, Paige and Peaches be around her all the time, 24/7. That's why I can't hang out with my own sister.
Okay, so y'all got her for making bomb threats. Y'all got her for making bomb threats, but y'all can't prove it. Y'all just going off of the phone.
Yeah.
So when do she go to court where she can get a bond so I can go buy my daughter out of jail? When do she go to court?
That's up to the prosecutor's office.
So who's the prosecutor? Because I need to go downtown. I need to go figure all this out. I'm meant to meet my lawyer down here. So where are we going?
Downtown Montgomery.
Where's Montgomery County at? I don't even know where nothing is here. Quit trying. Come here. You going home with Nana. So you know where we going. And you say she's here in Montgomery County?
Yes.
Okay, and you said y'all got proof that she sent the
I'm not going to discuss the details of the case.
Okay, well that's fine.
They don't have proof that she did it,
but you got but you got the iPhone.
Yes, I do.
So if you got the iPhone, then what proof do y'all got if she got the phone?
Because the evidence supposed to go downtown.
Man, give me the phone so I can see what evidence y'all done pulled up out this mug that you got. I'm going to figure it out.
All right. Do you have any other questions?
No, but yes, I will be reporting you though to my
Y'all, where the spot my lawyer?
Okay. Have a good day.
The first issue this footage presents is Miranda compliance. Under Miranda versus Arizona, decided in 1966, any person subjected to custodial interrogation must be advised of their right to remain silent and their right to counsel before questioning begins. The footage opens mid-interrogation. No on-camera advisement is documented. The custody test established in Berkemer versus McCarty in 1984 asks whether a reasonable person in the suspect's position would have felt free to leave. Hunt arrived following an arrest. She was almost certainly in custody for Miranda purposes. If no advisement was given prior to questioning, any incriminating statements made in this room are subject to suppression under the exclusionary rule. This is a preventable vulnerability that documentation could have eliminated entirely.
So, from the top, you're being interviewed in regards to the threats against the school. We talked yesterday. There were several times while we were talking, I felt like you were ready to say something and you were holding something back. Is there anything right now that you just want to get off your chest?
No.
Before we get into all this evidence?
No.
As you're aware, we got your phone, we did a download of it. There is an abundance of evidence that shows you did this. So it's not a matter of if you did it, I just want to know why. I want to give you the opportunity to explain why. Get out in front of it right now before we get anywhere.
I just told you I didn't do it.
That's not the question. We know you did it. All of this is information off of your phone.
And that's a fraction of what's off the phone.
Yeah, this is just what our analyst sent to us in a quick response. But all this, the user identification information, the phone itself, the IP addresses, shows it logs every keystroke when you're on your phone.
Yeah, I know that.
So when you tell us that you weren't on your phone after 8:30 at night, we know that's not true. When you say that you don't have this, you have 5 different Facebook accounts on that phone. One of them being the no-name, which posted the threat to Northridge. You also told me that you don't have any Gmail accounts, which you have several.
I don't got no Gmail account.
You remember when you had me show you the phone to get your chime?
Yeah, I know.
You know the email address associated with that?
Yeah, like that was the Gmail I used for my chime. It was like long time ago.
Okay, so that's one account. How many more are there?
That's the only one that I know of.
That's not how this works. Just because you say that I know of doesn't really.
No, I'm saying that's the only one that I know of because I'm not logging to no other Gmail. I had to make me a whole new Gmail account.
So how many? So does that make 2 Gmail accounts?
2 accounts because I just made me one. I just got this one like an hour ago.
So this is at least 2.
Yes.
And you just told me you didn't have any, and then you said you only have 1. Now you got 2.
Yeah, this is the one I just made. I can even show y'all this one. I just made this account. It's the Hunt Rayona 77@gmail.com. I just made it.
Okay. What are your different?
Since I've been working.
Which, how long is that?
It's going on a month.
Okay, so a month ago, you made, or you already had the Gmail account that you used to sign up for Chime?
Yes, I just made that, when I signed up for Chime, I just made that Gmail. Then,
so you just made a Gmail account a month ago, and you told me yesterday that you didn't have one.
So explain how these threats came from your phone. Make us understand that.
I told y'all what I know, and I don't know. I gotta go get my nephew in like 5 minutes.
So let's talk about something else that you were dishonest with. Nobody left your apartment yesterday.
Yesterday, I wasn't even home.
Tuesday, when you said that the guy from Florida.
Somebody did leave my house.
No, I reviewed the video. I've gotten the video.
Okay, y'all can believe it, but somebody did leave my house that day.
Okay.
I was upset, right? But I didn't make the threat. Okay, the girl named Paige Diorman, she said, so me and Paige was talking. I said, okay, it's so many threats in Springfield. So I said, so she had my phone that day and just made an account saying no name on my phone and threatened Dayton City Schools. I told her not to do it. I told her, and I'm telling you all the truth. I told her not to do it. And they said, she said that, you ain't gonna get in trouble. I said, yeah, honey, because it gonna come back to my phone. I said not to do it. And she was like, you're not gonna get in trouble. I said, okay. I said, but if it come back to my phone, I'm telling it all. But at the end of the day, I was still scared for my life and my daughters. So she made the whole post on my phone and made a whole new Facebook of no name. And I told her, don't do it. Then I told her I was about to get ready to go to bed. And she said, stay up for a minute. Let's see who gonna be able to see the threat. And I said, no, that's ignorant. Then I tried to delete it. I deleted off the thing. And that's when she deleted the Facebook off my phone.
These are complete lies. And you expect us to believe that somebody took your phone, created a Facebook account. Hold on, can I talk? The Facebook account that was created over a month ago, no name, it's all of a sudden created the day of the incident. I'm just telling you, I do not believe you one bit.
The charge making terrorist threats is grounded in Alabama Code Section 13, A11-122. The statute requires a threat to commit a crime of violence with intent to terrorize others or cause evacuation of a building or place of public assembly. An elementary school is unambiguously a place of public assembly. The statute does not require the poster to intend to carry out the threat. Intent to terrorize is sufficient. The elements are satisfied on the face of the post. The forensic evidence presented in this interrogation reflects the digital search standard established in Riley v. California, decided by the Supreme Court in 2014. Riley held that a warrant is required before law enforcement may search a cell phone, even incident to a lawful arrest. The depth of this extraction: 5 Facebook accounts, 7 Gmail accounts, IP address logs, and keystroke records is consistent with a court-authorized forensic download. A defense challenge to the scope of that warrant would be the first motion filed in any competent post-arrest legal strategy in this case. The interrogation technique employed here is consistent with the Reid Technique's confrontational phase. Under Frazier v. Cupp, decided in 1969, law enforcement may use deceptive tactics during interrogation, including overstating evidence, without automatically rendering subsequent statements involuntary. The legal boundary is coercion. Promises of leniency or physical threats would cross that line. The detective makes neither. The technique remains within established constitutional parameters.
Okay, you don't gotta
I don't. There's no, why would you tell us honestly what happened when we came and talked to you?
I'm telling you all the truth.
No, I didn't ask that. I said when we came and talked to you.
And I just said I was scared.
Of what?
I don't know, like I told her I was scared too when she did the post.
What were you scared of?
Because why would you threaten somebody to school?
Then why wouldn't you tell us so we could get in front of it, save people, and make people not
Remember,
scared?
your daughter's there.
I know, my daughter's there. That's
And
why.
you let all this happen.
And I tell her don't.
We were there talking to you about it.
I
You
told her
lied
do
to our
not make.
face.
I told her do not make the post. Do not make the post at all. I was scared to tell y'all. Like I'm not no snitch. So I was like, okay.
What were you scared of? Being labeled a snitch?
But you understand there's no difference between you allowing it and lying to us versus if somebody else said it. You're just as complicit when you allow it to happen. You're right there and watch that.
And then continue
Message
to
around.
lie about it when you're confronted. That
Yes.
just digs your hole even deeper.
And then you delete it trying to hide it. We'll ask you one more time before we get wrapped up. Do you want to continue to say that Paige did this? I mean, because it's not, it's not going to change the outcome, okay? If you are guilty of doing this, okay? You are involved whether Paige did it, it's the same consequences.
She on the run too. Like she's on the run and
On the run from what?
from chocolate. Like she got a warrant from chocolate. So she be lying. Like I've been knowing her since when she blew up this house in Springfield. Like she set the house on fire. Then that's when she moved down here and started back getting in trouble down here. And that's when
Did she get caught with the blowing the house up?
I don't know. I don't even know. I think yeah she did. She did 6 months.
So I got to ask, and I'm not being sarcastic, is Paige a multiple personality? Because everything you're talking that Paige is doing is exactly what you've done. Everything you describe, these fake accounts and all this stuff, and this is what you did.
I didn't make the fake account. That's what I'm saying.
Why are we supposed to believe that?
Like, I'm really not lying to y'all. Like, I'm telling y'all everything that really happened. Like, I'm not lying to y'all.
We understand, we already have the answers to the questions we're asking you. We're just giving you the opportunity to be honest, because when we ask you a question, and then we ask you another question, that second question is confirming this information that we already have.
Did you tell her to make that post?
No, I didn't.
Then why would you, this makes no sense, okay? You gave her your password to your phone to make a threatening post on your phone. Why?
I don't know. Like, I didn't tell her to do it, but she did it anyways.
But what was going through your head? Because you had to think that this was a good idea. You allowed it to happen. You're an adult. If you didn't agree with it, there is no reason why anybody would allow that to happen on their phone. If you said, if you want to go do this dumb stuff, go ahead and use your own phone. You're not using
Yeah,
mine.
I totally
But you
agree.
allowed it to happen on your phone.
We're gonna step out for a minute, just hang tight. We're gonna hang on your phone. We'll call your mom in a minute though, okay? You said you're not pregnant, that's somebody else, right?
Yeah.
Okay.
Is your sister still here?
Yeah, she's
Right.
Okay.
Let's step out here.
Let's examine the constitutional framework.
Hunt's partial admission that she was present, knew the post was being made, told the third party not to proceed, and did not intervene. Does not exculpate her. It satisfies the elements of criminal complicity under Alabama Code Section 13A42. Under that statute, a person who aids, abets, or knowingly allows a criminal act to proceed bears the same criminal liability as the principal offender. Presence plus knowledge plus inaction equals complicity under Alabama law. The fear narrative. Hunt introduces reluctance to be labeled a snitch carries no legal weight as a defense to complicity. Fear of social consequences is not a recognized affirmative defense in Alabama criminal law for this class of offense. The deletion of the Facebook account following the post creates a separate exposure under Alabama Code Section 13A10-2, obstruction of governmental operations, deliberately destroying digital evidence connected to an active investigation, compounds the original offense and directly supports the obstruction charge that accompanied the terroristic threats count. The lead detective receives a B+. The forensic preparation is thorough and the confrontational technique is legally sound. No threats, no proper promises, no coercive conduct. The account creation date contradiction is the most analytically precise, evidentiary move in the footage. However, the absence of an on-camera Miranda advisement is a documentable procedural gap that creates unnecessary suppression risk. In cases where the evidence is less overwhelming, that gap could be outcome determinative. Rayona Hunt receives a C. Each evolution of her narrative from denial to third-party deflection to partial admission was extracted only after direct confrontation with specific evidence. This incremental admission pattern is precisely what prosecutors use to demonstrate consciousness of guilt. Most critically, Hunt never invoked her Fifth Amendment right to silence, nor did she request counsel under the Sixth Amendment. Under Edwards v. Arizona, had she requested an attorney, all questioning would have been required to cease immediately. That single invocation could have changed the legal outcome of this case. Montgomery County law enforcement receives a B. The 3-day turnaround on a multi-platform digital forensic extraction reflects institutional capability. The charge selection terroristic threats and obstruction accurately tracks both the evidence and the legal standards. The grade is capped at B solely by the Miranda documentation policy gap, which is a correctable training issue. The lesson from this footage applies to both sides of the interrogation table. For law enforcement document, Miranda advisements on camera, without exception. The strength of the underlying evidence does not reduce the legal obligation. A suppression motion does not require a weak case. It requires only a procedural gap. For anyone facing custodial questioning, the Fifth Amendment right to silence and the Sixth Amendment right to counsel exist precisely for situations like this one. They are not signs of guilt. They are constitutional protections. Invoking them is not obstruction. It is the exercise of rights the Supreme Court has repeatedly affirmed. Silence and counsel preserve options. Unguided statements eliminate them. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching. And don't forget to subscribe to our channel for more content on police court interactions.